Alex here with part 210 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are: number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the judge's order denying my motion to include those new arrearages. No worries, because all she does is send me to the child support enforcement case, which is FV16 case. I am going to end up filing the same motion in that case, and then it will be granted. In fact, that's the motion that leads to a hearing, which is the final hearing in the series. So mindset was, for the most part, annoyed. I found the judge's ruling irritating. The main reason I found it irritating is because she didn't cite a law that said she was allowed to do what she was doing. I think she just decided to do it because she felt like it. It would be better if there was some kind of statute or rule that required these types of cases to go to the child support enforcement case if that case was open, because then we, as proper person litigants, would know what's going on. Instead, we have to try and read the mind of the particular judge that we are in front of. With attorneys, it's not a big problem because they're in front of all the judges all the time, and so they kind of figure out what every judge wants. But with the non-attorney, we're really disadvantaged because we don't know what these judges want. We're not in front of them all the time. That's not our job. And so when you see something like this where they just have invented rules that some of them follow and some of them don't when they feel like it, it's annoying. It's a waste of time for both you and the court. But as I mentioned, in the end, it was granted anyway. I just had to refile it with the FV16 case, which is the hearing master who is handling the child support stuff. So all that being said, let's go ahead and take a look at what the judge has filed. Here we have the order denying motion to amend judgment on child support and medical arrearages. She starts off with her standard introductory, paragraph indicating she's reviewed all papers and orders associated with my motion to amend the judgment. She goes through a bunch of findings, which aren't really findings. It's more of a procedural history. Number one, we are the parents of a minor child. Whoa, hold on a second. It looks like she didn't read. She didn't read my motion, did she? Because this doesn't have the termination of parental rights mentioned. So I can tell right away she didn't read that, unless she mentions it later. Let's take a look. She's mentioning that I am stating that an existing judgment on child support and medical arrearages should be merged with a new judgment. She's going into her conclusions of law. She's mentioning my notice of appeal. Generally, that does divest the court of jurisdiction. Watch my video on the topic, jurisdiction divested on appeal, if you want to learn more about that. But she should be acknowledging that matters collateral to are allowed to be considered. The court's finding that my motion to amend judgment is... so she's recognizing that my appeal only seeks to appeal the award of attorney fees. And so she is finding that my motion does not affect the merits of the appeal, and she's retaining jurisdiction, which is good. She's citing Rule 13, which is used against my ex for not filing an opposition. And then she says, as there is a separate case regarding enforcement of child support, I shall seek enforcement in that case. So she says that she's basically saying I can resubmit this motion in the child support action. Yeah, guys, I don't think she read my motion, because she would have mentioned that my ex's parental rights have been terminated, and she didn't do that. That's a red flag that she just didn't read anything and just filed this. She probably just figured, hey, it's a child support thing. I don't want to do this. I'm going to send him to the other judge. And that's what she did. We have the certificate of mailing under Rule 5 indicating this document was mailed to both me and my ex. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.